Welcome back to Sunrise City. We're joined now by Mr. Obono-Obla, who is a legal practitioner, also a member of the APC's Legal Directorates for the Presidential Campaign Council. Morning, and thank you for joining us today. We just listened to the representatives of the PDP about this judgment, who, while highlighting the grounds for that judgment, he did say that the tribunal, one of those grounds was predicated on the use of the card readers. And he did say that the Electoral Act doesn't recognize the card reader, and then there's a ruling, an authority cited, a recent one at that, about the card reader. So bottom line of what he said is that judgment was predicated on a faulty foundation.
I don't agree. I do. Can I go? Yes, I do agree with my left friend. The case he has cited, the case in Lake State, Ambuke and Simi Abat, the facts and circumstances of that case are dissimilar to the facts and circumstances of the Kuku and Wike, because in the Lagos State case, the petitioners made the non-use of the card reader as a ground on which their petition was premised upon. But that of Rivers State, the grounds for the petition was not specifically premised on the non-use of the card reader. It was just a fact that was used to support the grounds of non-availability of resources, thuggery, violence, snatching of electoral materials. Because if you look at the Electoral Act did not say or did not provide that you can use the non-use of the card reader as a ground. The Electoral Act says the grounds for a petition are maybe non-qualification of one of the candidates, corrupt practices, and so forth and so on, but not the card reader. So if you use the facts of the Lagos State case to begin to do analysis of the Rivers State case, you are on very, very faulty grounds. The cases are not the same. So that principle will not apply to the Rivers State case.
But he is saying that it was part of the grounds for which judgment was delivered, and that's where they find a challenge with it. In fact, he quoted, just as you have copiously too, from the Electoral Act, both in terms of grounds of petition, but he also supported it with the grounds for which the judgment was given. And so are you saying then that even though that it was part of what was used to support the case, if having delivered the judgment as, or having cited the card reader as part of the grounds for delivering judgment, it doesn't invalidate the judgment?
Yes, that's my argument. The petitioners pleaded that the card reader was not used. But that does not mean that the grounds for their petition was premised on the non-use of the card reader. As in the Lagos State case I have cited before. In the Lagos State case, the non-use of the card reader was made a ground, and the Court of Appeal said, look, non-use of the card reader cannot be a ground for an election petition because it is not provided for in the Electoral Act. I think Section 138 talks about the grounds for an election petition. So there were other grounds, the River State petition, there were other grounds which I have mentioned before, particularly, most importantly, non-availability of resource sheets. I know I can give a personal experience, a case I did in 2008, Imoke and Dr. Paul Lupo in Cross River State. Our case, I was the counsel to Dr. Upo, who was the petitioner, and our case was that the result sheets were not supplied to the 2,217 polling units in Cross River State. And we lost the case in the tribunal, but on appeal, the Court of Appeal agreed with us. And so if result sheets were not provided for, you do not need to call 2,000 witnesses. You do not need to call 1,000 witnesses. In the Cross River State case I just cited, it's reported a decision of the Court of Appeal that led to the removal of Imoke, who was the governor. We called only one witness to prove that fact. And the Court of Appeal agreed with us because it's a serious issue where you say, where the petitioner alleges that result sheets were not provided. And in the River State case, they say result sheets were not provided. So it's not as if the case in Rivers, the judgment in Rivers case was principally premised on non-use of the car reader.
All right. Part of their what he also raised is the tribunal judge. He says that if you're removing a tribunal judge and assigning him to another matter based on whatever reason, that if a new one comes in, he's supposed to start the case de novo. And that didn't happen in this case. He also says that he doesn't see how a judge can give a ruling based on the case that he didn't hear.
That is the general principle. But we are talking about an election petition. The superior courts or decided cases are to the effect that election petitions are sui generis. They are of a peculiar character and nature. So you do not use the principles that the courts have decided upon in ordinary civil proceedings to begin to apply them to an election petition. So that is it. So I do not agree with him. This is an election petition. This petition, the law has provided that it must be heard within 180 days. So if a judge is asked to step down, or if one of the judges is removed, it will not be good to start de novo, taking into account the fact that the tribunal has 180 days from the date of filing of the petition to hear and determine the petition.
I'm quite sure, sorry Mark, but I'm quite sure you must have also been following what some of the PDP members are saying, even from their legal team. The question is about when you talk about substantial compliance, they're asking the question, with few eyewitnesses that have emerged in that particular tribunal, does that give a true representation of what went down in the entire River State?
I have cited the case of Upo and Imoke, the judgment of the Court of Appeal Calabar Division, to buttress my point that you do not need to call 2,000 witnesses. You do not need to call 1,000 witnesses. You do not need to call witnesses from all the polling units in River State, because election petition is also determined on documentary evidence. I can even mention one, the case of Adams Oshomole, the governor of Edo State. His case was principally, determined on documentary evidence. Even the case of Dr. John Fayemi and Oni was also determined on documentary evidence, because it is very, very impossible to call witnesses from all the polling units in a state, and then you have to hear this case within 180 days, because 6 months, and it's not possible. So the law says you have to use oral evidence and also use documentary evidence. Maybe the tribunal in the River State rely mostly on documentary evidence, because if you use documentary evidence, you do not need to call oral evidence, because you cannot use oral evidence to contradict documentary evidence, because the documents are there. The documents speak for themselves.
I'm just wondering, though, if this case had flipped in favor of the PDP, would you have raised issue with the fact that when the new tribunal chairman was sent or assigned to that court, they did not start all over again?
That is a political question. I would not, because, as I say, in as much as we are lawyers, in as much as we are partisans, we are ministers in the temple of justice as lawyers. So how do you expect a case to start de novo when you have 180 days to hear this petition and give judgment?
Oh,
I was saying that in election petition, the law is different. The law is different. The principles are different.
There are things. So people will say that there are some basic minimum that lawyers both from the APC and the PDP must agree to, and that's why they're called principles. Did the PDP, lawyers in the PDP, or just lawyers generally, do they agree on this principle that, election petition tribunal cases are different, and if a new judge is assigned or chairman is assigned, they do not have to start all over again? Is that a general principle that all lawyers agree on?
That point has never been, determined by the Superior Court. Maybe from the River State case, from the Akwa Ibom case, the Supreme Court will make a pronouncement on that issue of the stepping down of a judge in an election petition. Does that require a case starting de novo? Ordinarily, in an ordinary civil proceedings, the case has to start de novo. But in an election petition, in view of Section 286 of the Constitution that says you have to hear this petition and give judgment within 180 days.